I always like to talk about how important it is for employers to take ownership over safety. You define your reality. If you don't define your reality, somebody else is going to define it for you. So you need to be proactive in safety matters. You need to develop and practice a written safety program with regular documented training. And you need to make sure that management and employees are committed to safety. And what Rich and I are going to talk to you about today is very important when the safety compliance officer comes out to your place of business and begins to do an inspection, because those points jump out at the OSHA personnel immediately. They can tell whether your company is committed to safety right away. We're going to talk today about the inspection process, and we're going to highlight some things. We have about 30 minutes to talk to you. That's not a lot of time. We do have a lot of material. So we will be giving you snapshots into our expertise on certain areas. If you have any more in-depth questions, feel free to contact us. Well, what is OSHA looking for? So when the federal government comes knocking on the door and they say, "Hi, we're from the federal government, we're here to help you," how do you respond to that? They have certain priorities that they're obligated to follow. So we're going to talk about inspection priorities, preparation, and the actual process. As I said early on, OSHA is looking for management commitment and employee involvement. They want to know, do you have safety committees? They want to know what management personnel are on the committees. They want to know if you're doing a worksite analysis, job safety analysis, hazard prevention and control, and what kind of education you're providing to your employees on workplace safety. That's really what they look for initially when they come bopping in your door and as they begin to review your documents. They do have priorities. The first is imminent danger. If an OSHA compliance officer is driving down the street and they see your workers on a rooftop without tie-off or fall protection, that is an imminent danger. Somebody's going to get hurt. So that is a high priority, the highest priority. Level 2 is fatality or catastrophe. Now, as Rich may talk about as we move along here, most of the inspections in 2016 and moving into 2017 follow level 2. And you might wonder why. Well, that has to do with the reporting, calling and reporting of amputations, hospitalizations, etc. Complaints by employees. Boy, oh boy, do we have some of those in our office. You get a disgruntled employee, and next thing you know, they've got OSHA on speed dial. OSHA comes out unexpectedly and checks out your plant. Also, we happen to see retaliation cases from disgruntled employees. So that is a factor you need to consider in your management of employees. Programmed inspections, I mean, that's not, I don't see too much of those. I don't know if Rich does, but there are certain programmed inspections that OSHA has nationally, and in every region has certain programmed inspections as well. And finally, level 5 inspections, that is follow-up inspections. You've already been cited, and that is resolved. And OSHA will come back out and make sure you're doing what you're supposed to do. Mr. Barcum, do you have anything you want to add?
Yeah, there's just a couple of things that I do want to kind of expound on regarding the inspection priorities. The first is, Carl had alluded to the fact that a large majority of the OSHA inspections that we are seeing now are due to that level 2. And that really comes down to the change in the reporting structure for fatalities and catastrophic injuries that took place on January 1st of 2015, requiring the employers to report hospitalization of one employee. Still maintain you had to report the fatalities, but they also added the loss of an eye and the amputation injuries need to be reported. And that has resulted in approximately about 80% of the OSHA inspections, or about 80% of their workload right now is centered really around that. And because of that, I want to make sure that everybody on the call understands what the rules of engagement there are. OSHA requires that a fatality be reported within 8 hours. But it goes a little bit further than that, and that fatality has to be reported within 8 hours if it occurred within 30 days of the injury. Hospitalization of one person, amputations, loss of an eye, those need to be reported within 24 hours of that event happening. So 24 hours after an amputation, 24 hours after the loss of an eye, or the hospitalization. But that, again, that also goes further. They need to be reported within 24 hours as long as that injury occurred within 24 hours, or that amputation took place within 24 hours of the actual injury taking place. So it's not just as simple as, unfortunately we had an employee that lost a digit or a limb. You have to make sure that when you're notifying OSHA that you're following their rules. Because even if you inappropriately report an injury, the citations that they find as a result of that reporting, they're going to stick. The other one I just want to point out is the level 3 is just because an employee complains to OSHA does not mean that they are going to show up. Sometimes what they will do is if it's what they consider a low hazard, they will contact the employer, give them a chance to respond without actually showing up. So, an employee complaint isn't all doom and gloom. There are other avenues that they will use to adjudicate those, or to make sure that those issues are abated. Another thing that I just want to kind of touch on real quick is in October, we had a bunch of changes that came through. Carl alluded to the retaliation. We had there's some anti-retaliation language that was added to the OSHA regulations. But they also added what they're called weighted inspections. And really what it comes down to is that it gets back to that level 4, that programmed inspections, and how they're going about picking those. And what OSHA has done is that based on a company and what they do, based on the hazards that a company or employees at that company might face, or based on a company's safety record, which we will get into the new OSHA record-keeping rules here at the end of our presentation today. But based on those, they're assigning what they're calling inspection units. So if it's a high hazard, they might assign 7 inspection units. If it's a lower hazard, they might assign 3 inspection units. And this is really how they're going about planning those level 4 type of inspection activities.
I didn't know that. Thanks. Thanks, Rich. Well, here we are. We're at the inspection. Now, why do you care? Let me tell you why you should care from my perspective. When the compliance officers come out to your place of business, they're going to talk to you, and we'll get into that here a little bit. They're going to talk to you. They're going to walk around. They're going to gather some information, and then they're done. And then they'll issue a citation, maybe, not all the time, but most of the time they do, and then you have to deal with it. Well, what, in my perspective as a lawyer, they are doing is finding evidence. They're creating their case. And I'm not saying this as a battle-hardened guy. I'm just saying that we have cases that companies are paying us attorney fees to defend that probably wouldn't be there if the people at the plant knew how to talk to the compliance officers when they come to the plant and do their inspections. So what we're going to talk to you about is very important. I want you to understand it's not in writing, it's not on our slides, but OSHA has the burden. They have to prove their case. And so they have to prove that certain regulations apply to a hazard. They have to establish that the employer failed to meet those requirements, and that employees were actually exposed to a hazard. So what you say to the compliance officer goes into their file, and it gives OSHA the impression as to whether or not you were aware of hazards and whether or not you were aware of safety regulations. So enough of my babble, but it was very important, and I wanted you to know that. What do you do to prepare for an inspection? You better have a team. And what we mean by that is, who's going to be there and talk to the OSHA people when they come to your door? You should have a management person already designated to handle OSHA when they come to your place of business. You should also have what we call an inspection box. That is a camera, a tape measure, maybe something to write down some notes so that you follow, or whoever you've designated follows the compliance officer. And when we use compliance officer, that's the same as inspector. So I don't want you to be confused. The compliance officer is OSHA's term for inspector. And, you know, you can follow around. You should follow them around. Take pictures of what they take pictures of. Measure what they measure. Write down notes from whatever they're doing. I put this here, OSHA readiness checklist. We have one prepared in the office. It's just things like, oh no, OSHA's here. Quick, call somebody. Get the cords out of the way. Make sure that you've got the fire extinguishers where they're supposed to be. Just real quick items that you double check immediately. And we can give that to you if you need it. And then inspection procedures, we'll talk about that, but you need to be aware of what happens. So that's what we're going to talk about next. What's the inspection process? A compliance officer, or as I said, an inspector is going to come to your place, and they're entitled to take a look at your operations without unreasonable delay at a reasonable time. What is a reasonable time? Let's go backwards. A reasonable time is your normal business hours. If you're open and operating between 8 and 4:30, that's the reasonable time. Unreasonable delay, I'm sure Rich will affirm this, but normally no more than an hour, maybe 2 hours max, is all they will wait. Otherwise, they're going to go get a warrant, and they're going to think you're hiding something from them. This is the sort of process. They're going to come in, you're going to greet them. It's very quick, it's informal. Hey, how you doing? You get a copy of their documentation, such as their badge and whatever official identification they have. I'd always recommend you make a copy. You'll go into a room, and you're going to talk about why they're there. Try to pin them down as to why they're there. Then there'll be a walkthrough, and then they'll have a closing conference. We're going to talk about each one of those aspects of the inspection. Greeting, it sounds basic, but it's sort of like if you're in sports, you go through basics over and over again. If you're in music, you practice the basics over and over again. That's what we're talking about. Just treat them with respect. Be nice, friendly to them. Give them the appropriate information. We've talked about this. If they arrive during non-business hours, advise them of the business hours. You can be firm on this, and Rich can comment otherwise, but at least in this part of the state of Ohio, they've been very cooperative. All right. That's what I said. You got to notify everybody that OSHA is here. Then you have the opening conference. You've already identified who you're going to have participate. You'll have a management. If you have safety committees, you'll have somebody from the safety committee. I would recommend be there at the opening conference. Be polite, cooperative, listen to the questions, answer the questions. Do not volunteer any unnecessary information. OSHA personnel are always going to ask for your OSHA logs. 300, 301 logs. Perhaps your workers' comp claims, they'll want to see that. So do not be surprised and have those ready to go. This is just some more detail on the opening conference. I want to make sure that you understand there is information that they are not entitled to. I want to emphasize, as Mr. Barcum would as well, they're not entitled to personnel files, okay? Don't give them personnel files. They're not entitled to it. So that's all I really have to say on that. Rich?
I'm just going to add one thing to that, Carl, is in all cases, I advise clients to not put training records with personnel files, not put medical records with personnel files, because we have gotten into situations before where we do have a compliance officer or an attorney asking for information, and I want them to be able to ask me. If they ask me for a training record, I want to give them a training record. They ask for a medical record, I want to give them that medical record. I don't want to give them too much. So just make sure that as you're setting your file system up, you kind of keep that in the back of your mind of what you could be asked for and how they could ask for it.
Right. Yep. And they'll also ask for, most of the time anyway, standard, they'll ask for your safety data sheets, basic training programs, and like Rich said, it's very easy to give them the information if you have it separated out. And that also gives the compliance officer a very good impression that you're prepared and you're ready to go. Right, let's move on. Make sure we get through everything here. Mr. Barcum, I think this is yours.
Yep. All right. Go ahead and put it all up there. When we start talking about the walkthrough and the inspection, you can see our notes up on your screen here. Really, what I want to emphasize here is you need to stay with your inspector at all times. They do not have free reign for your facility, so make sure someone is with them at all times. If they talk to someone, make a note of it. If they take a picture, you take the same picture. If they are going to run an air sample, we want to run an air sample that's right next to theirs. So we have the same information that they have, because they are not obligated to share their notes with you, and in most times they're not going to. If you have trade secret information in your facility, you need to make sure that they are aware of that. If they point out a perceived violation, and at this point, when I'm talking with a compliance officer, everything is alleged. Nothing is written in stone until it goes through their boss, who's the area director, and he or she issues a citation. So be really careful that you I want to make sure that you understand that just because a compliance officer in and of the course of their inspection identifies a violation, you may or may not feel the need to fix that. If you don't feel like it is a valid violation or a valid citation, it is okay for you to take a step back and fix that at a later date and do your homework. If it's something that is obvious, please go ahead and fix it. Compliance officers, they're not dumb people. And a lot of times if you do fix something that is valid and is easy to fix, they will take that into consideration. In terms of employee interviews, put them all up there. I just want to make sure that everyone understands that OSHA has rights, the employer has rights, and the employee has rights. When this happens, what's going to happen is they're going to tell you, I want to talk to this employee, or they want to talk to Carl. Well, you go get that employee, you bring that employee to them, as opposed to letting that compliance officer have that conversation with them while they're out on the shop floor. Right. Understanding that every time that you give them access to your shop floor or your job site, anything in plain sight, they have the ability to interact with, they have the ability to investigate, and they could end up issuing citations for those types of things. Which brings me to a point that I actually missed on the last slide is if they do want to go to a, want to go to a certain area within your facility, it is okay to put your coat on and take them outside. It is okay to get the umbrella out if it's raining and take them outside. Take them to that location in your facility without walking them through the majority of your facility if you can avoid it. And they expect you to do that. They are okay with you doing that. You are not going to hurt their feelings.
Okay, then you'll have a closing conference after they've walked through the plant and you've walked through there with them and taken pictures of the same thing they took pictures of, taken notes of what they've taken notes of. We're done in that sense. There will be a short closing conference. Now, they're not going to tell you a whole lot at this point. They'll say a little bit, well, we really didn't find much, but we think we might have a problem here. Then they'll take it back and analyze it. They may even have engineers analyze their findings, perhaps an industrial hygienist. Then they run it by the area director before they issue the citations. Many times, they will have then a more formal closing conference. It'll be a phone call generally where they'll call and they'll say, look, this is what we found. We're going to issue a couple of citations here, and here's why we're doing this. Please, at that point in time, that's not the time where you start arguing with them, okay? You don't start arguing and saying you're wrong. That's their findings. You have opportunities after that for an informal conference or to file a notice of contest, but that's for a different webinar. That's it on that slide. Okay, we wanted to talk about a little bit about OSHA record keeping. We mentioned reporting of OSHA incidents. I want to just kind of touch briefly on OSHA record keeping and some of the changes that we've had in the last year and a half, 2 years. The cases that need to be recorded on our OSHA 300 log haven't changed. You still need to report work-related injury or illnesses that meet a certain severity criteria. OSHA considers an injury or illness any abnormal condition or disorder. And it's important that you guys understand that it is not an exposure. So if I am working in a welding shop and I feel like somebody has had exposure to welding fumes, unless they are starting to see signs or symptoms and there is medical treatment that is necessitated, those are not considered OSHA recordable injuries. And the reason we're going through this is that as of January 1st, the rules of engagement have changed, and it has become extremely important that injuries do not get over-recorded on your OSHA 300 log. If the case is work-related, it's going to be caused by events or exposures in the work environment, which means that it happens there. It has to be significantly aggravates a previous condition. If you want to go look at the OSHA regulations under 1904.5B2, there's a list of activities that are not work-related, such as, if somebody gets a candy bar out of the vending machine in your lunchroom, they're eating that candy bar and they choke and pass out and hit their head, that's not going to be work-related. So they exempt some of that stuff. The severity criteria, death, definitely has to go on your OSHA 300 log. If someone loses consciousness, even if for a brief period, if it results in days away from work, restricted work or job transfer, or medical treatment beyond first aid. And you'll really need to go look at the OSHA record-keeping regulations to look at what their definition is. But anytime that you have an injury, you should be looking at those. Now, which brings me to, okay, we understand what the rules of engagement are. Now, this really brings me to
the reason why I stated that we should not be over-reporting injuries, and it really comes down to these new, what they're calling this new and improved OSHA tracking of workplace injuries or illnesses. Prior to January 1st, our regulations were, well, we had to keep a 300 log, we had to do our summary, we had to post our summary from February 1 to April 30th, and we had to have the OSHA 301, which is your incident accident investigation or your accident report. The only time we had to turn those over to OSHA is if they asked for them during an inspection, or we got a notification from the Bureau of Labor Statistics where we had to provide that information. In May of 2016, they amended it to basically say that any employer that has employees in an establishment with 20 or more people, we have to start reporting this stuff electronically starting this year. One thing I do want to point out here is they don't say companies with 20 to or over 20 employees. They say establishments. OSHA requires that record keeping, your OSHA 300 log, be kept by establishment, which means that if I have three separate places where I am doing business, each place has to have their own OSHA 300 log. For our construction companies, that really comes down to is that project is expected to be in operation for greater than 365 days, 1 year. And then we have to have that establishment has to keep their own separate 300 log. Okay, it becomes really important when you start really digging into what the requirements are, because now OSHA requires establishments with 20 to 249 people to annually submit their OSHA 300A summary. That's their summary sheet. Establishments with 250 or more employees have to submit everything. 300 log with the names, 300A your summary, and then your 301 forms, which are your accident reports.
Hey, Rich, this is not on our agenda, but why do you think OSHA wants the more detailed information for the larger employers?
Generally because that's where your higher hazard employers are going to be. There's just more room for the data, and they had to draw the line in the sand somewhere. I haven't been able to find out, a hard and fast. This is why they wanted that, but that's just my own speculation. Okay. Yep. How the information needs to be submitted. We're still waiting to find that out. Yeah, OSHA was supposed to have this rolled out in as of February 1. As of this morning, there still is not a set electronic reporting format. They intend to make it compatible that you could just enter in the information, or you could actually fax or actually upload your own information. But I wish I had more information to say this is exactly how we have to do it.
Yeah, because I'm getting calls from people asking how they.
So am I, and I'll be honest with you, Carl. If you go back a few years when the health exchange was first rolled out and all the issues that they had, I'm kind of seeing that for safety right now. And we're still kind of in a wait and see. If you're in contact with Carl or myself, one of us will definitely let you know when that takes place. The good part about that is, for the first 2 years, there's a roll-in to this. In 2017, regardless of your size, if you're 20 or more employees at that establishment, you need to submit only your summary. So our larger companies, those companies that are over that 250 employee threshold, this year we're still just giving them the summaries. And that's going to have to be done before July 1st of this year. Next year, before July 1, employers with 20 to 249 employees are going to have to submit their 300A or their summary form, and that's when the larger employees have to submit accident reports, the summary, as well as the 300 log with the names on it. In 2019, all that takes place, but we have to have it done before March 2nd. So, you know, a couple of things. OSHA's given themselves enough time to work out the kinks in the electronic reporting system, which is good. They're giving us as employers a chance to get used to this system. So that's a good thing. The last thing I want to kind of mention about this is what OSHA is going to do with this information. And if you go back when Carl was talking about the different levels of inspection and the programmed inspection, so what we have here is we've already talked about these, the higher hazards being given more inspection units or inspection credits. So they're going to go after the ones with 7s versus 3s. Well, how do you think they're going to assign companies to this? Well, it's going to be based on this information that gets reported on this electronic reporting system. So that's one impact, that if a company, and I run across this almost every day, where a company reports everything or records everything on their OSHA 300 log, if they report that just on the surface, it's going to look like that employer has a really bad safety record or a worse safety record than what they do, which could put a bullseye on your company unnecessarily. The other piece of this that I think a lot of employers are really missing is the summary information is going to be out there on OSHA's website, just like inspection data is out there on OSHA's website. So with a lot of us now, where having a good safety record is kind of our hunting license to be able to go in and get work with the company, where companies are screening subcontractors based on their safety record. This is extremely important with companies that have a process safety management program. There's that loss of potential earnings based on the information that's out there, because it's going to be easier for companies to find out what your safety record is all about.
Well, it's still going to be easier for plaintiff attorneys to go fishing through the records because it's public information.
And, you know, and that gets us in Ohio. That gets us all into the whole VSSR argument and that as well. So you're absolutely right. Absolutely.
I think maybe we, as everyone knows who's been on our webinars over the last year, we usually do these every 2 to 3 months. So perhaps maybe the next webinar we would do more focused on actual recording of incidents and some of the ramifications of both proper and improper recording. Well, without further ado, I think, believe it or not, yeah, we went through all 30 minutes. We want to thank everyone once again for attending. Appreciate it very much. Appreciate your time and attention. If you have any questions whatsoever, I believe our contact information is available. Feel free to contact us, and have a great day.
Thank you.